This meeting is being recorded.
Darshan, you may have to unmute yourself. Sorry.
So very good morning, good afternoon, depending on where you are, to everyone who's joined us today for this session on how business, financial and technical experts add value to commercial disputes and arbitrations. We appreciate you making time on a Monday to join us in this discussion. By way of introduction, I am Darshan Patel, a partner at PwC, and have assisted clients in expert witness services at the ICC in London, the AAA, and arbitrations in India. I'm joined in this discussion with 5 additional speakers who have come together today to bring out multiple dimension view on the topic, which has been emerging in international as well as Indian arbitrations regarding the use of experts in the resolution of disputes and during arbitration proceeding. Our aim was to come forward with views from different parts of the globe, and I'm sure you'll be getting a flavor of this as I introduce you to the co-speakers. The list of speakers for this session in alphabetical order is Aditya Singh, a partner at White & Case in Singapore; Amanda Lees, partner at King & Wood, Mallesons, Singapore; Geetu Singh, partner at PwC India in Forensic Services; Nicholas Peacock, goes by Nick, partner and head of International Arbitrations Practice at Bird & Bird UK; Sumit Makhija, partner PwC India Forensic Services; and Tomas Furlong, partner Herbert Freehills. A quick introduction, a slightly more detailed introduction of each of the speakers. Nicholas is a partner and head of the International Arbitrations Practice at Bird & Bird in London. He's also previously been in the Southeast Asia, where he's headed his previous firm, Singapore Arbitration Practice, for a number of years, and he's enjoyed a 20-plus year career in international dispute resolution. He's been heavily involved acting on India-related commercial disputes for the last 15 years. Nick has also acted for and against state governments on commercial disputes and sits as an arbitrator on India-related disputes under various institutional rules. A quick introduction to Sumit Makhija. I'm pleased to introduce him. He's a colleague partner at PwC. Sumit will be moderating the discussion today. He's experienced in forensic services and based in New Delhi. He has over 25 years of professional experience in the areas of anti-bribery reviews and investigations, as well as assisting clients on disputes. And he's handled a few of the largest anti-bribery investigations in the country, as well as representing clients in front of government authorities both in India and the US. He's also acted as an expert in cross-border dispute matters. The next I'd like to introduce is Amanda Lees. Amanda is a partner at King & Wood Mallesons, who is based in Singapore and specializes in international arbitration. She acts as counsel in large complex disputes, including an investigator state arbitration brought by an Indian investor over an investment in Indonesia. Amanda sits as an arbitrator regularly and has 22 appointments as arbitrator, including an emergency arbitrator and presiding arbitrator. An introduction to Tomas. Tomas is a member of the India team and partner at Herbert Freehills in Singapore. He focuses on commercial arbitrations and Singapore court proceedings related to arbitrations, particularly in tech and private capital sector. Much of his work involves disputes in or parties from India, as well as China and Philippines. The next I'd like to introduce is Aditya Singh, who's a partner at White & Case, where he focuses on international arbitration matters and white-collar investigations, as well as acts as counsel in high-stake commercial and investment treaty arbitrations, and has extensive experience in the Indian market. He has represented Indian companies and foreign investors in commercial arbitrations over the last 2 years. Next and lastly, I'd like to introduce my fellow colleague partner, Geetu Singh. She's a seasoned expert witness and comes with extensive experience in damage quantification in international and domestic arbitrations, valuations, in litigation situations, several shareholder and joint venture disputes, and a large and complex infrastructure in disputes. Geetu's opinions have been tested from time to time by arbitral tribunals, regulatory authorities, and enforcement agencies. Geetu has also been recognized in the Who's Who Legal as a leading expert for arbitrations from India in our GAR. I'd like to now invite Nick to share an overview with you on the emerging landscape in disputes and arbitrations. Over to you, Nick.
Thank you, Darshan, for that welcome. Thank you to PwC and MCIA for the invitation to join this august panel to discuss what is a very important topic. And I'd like to congratulate MCIA on convening another India ADR week. A busy day already, I think, and a busy and full program ahead. And I understand the Chief Justice himself gave a welcome to the week ahead. So it's great to see this event and this week really getting on the program and raising its profile. I think also a hybrid program of necessity in the last few years and of choice this year, I think enables those of us who are based in Europe, as I currently am, to join, albeit rather early in our day. But I hope those gathering in person will have fun and enjoy reconnecting and look forward to seeing you all at an MCIA annual conference before too much longer. So I've been asked to give some comments on the changing landscape for arbitration in India, which I've witnessed over the 15+ years that I've been involved in dispute resolution in relation to the jurisdiction. I think some themes remain. The predominance of ad hoc arbitration, for example, which is not a problem of itself. London and Hong Kong, for instance, also have very busy and thriving ad hoc arbitration markets. But I do think the growth of institutional arbitration, which we've been talking about for many, many years in India, has been encouraging and is great news for the options available for dispute resolution for parties in India. Many institutions, of course, are making contribution, not just the MCIA, although I'm pleased and proud to be connected with that as a council member. Many of the largest corporates in India are making use of institutional arbitration, and we also see the courts supporting it increasingly. The Bombay and Supreme Court, for example, have both used the MCIA as an appointing authority on matters in India. But other institutions should not be ignored. Of course, SIAC has done a great job of making itself an embedded part of the market in India. And I think interestingly there, in terms of recent trends in the last few years, we've seen such overseas institutions appearing not just as seats outside India, but also to administer arbitrations within India. And I myself have had the pleasure to be an arbitrator for the SIAC on two matters recently, which have had a Bangalore seat and a Mumbai seat, which I think shows again the growth of institutional arbitration in India and its increasing acceptability as a dispute resolution mechanism for both onshore and offshore arbitrations. And aside those other two, those institutions, of course, the ICC, LCIA, many others should also be given thanks for that. So how has arbitration changed for clients in India? Well, I've been privileged, as has already been mentioned, to act for Indian clients while based outside India, but based in Singapore for several years and based in London for many years now. India has always been an important component of the dispute landscape in both those jurisdictions. I think there's been progress and development over that time. It's not always been linear, but then progress very rarely is. I think it's a story of increasing familiarity of parties, council, and courts with the international arbitration process, and an increased trust in that process and support of that process, recognizing, of course, as we do, that international arbitration works best when courts support the process, but resist invitations from parties to interfere with it. It seems a long time now since those of us who draft arbitration clauses in relation to Indian transactions used to exclude Part 1 of the 96 Act, save for sections 9 and 27, in an effort to try and prevent the Indian courts from accepting jurisdiction to supervise arbitrations which were seated outside India. Of course, the 2012 decision in Balco overruled Bharti International, to confirm that Indian courts would not accept such invitations to exercise jurisdiction over arbitration seated outside India, but then left parties with the difficult choice of not being able to seek interim relief and access Indian courts in relation to arbitrations taking place outside India, which of course happily has since been restored through the 2015 arbitration ordinance. Now, for a while, of course, the 2015 ordinance gave India probably the fastest arbitration timetable of any jurisdiction in the world, which was a challenge and I think a shock to the system, but perhaps also a good one. And also in 2015, removing the automatic stay on enforcement of arbitration awards that had appeared under Section 36 of the 96 Act, I think was a sea change for arbitration in India and something I myself have been calling for quite some time. And the courts have supported the growth of the arbitrator's jurisdiction. There was a question over whether fraud was arbitral in India for many years. And that I think has been more or less resolved by the 2015 Swiss timing decision, which overturned Maestro Engineering. And more recently, we've seen our Indian courts really taking a lead in the use of emergency arbitration by confirming that emergency arbitration awards are enforceable in India, which I think has really given that institution and that device within arbitration a real support. And what about expert use in international arbitration? That's the topic we're on today. It's an important component of any arbitration process. I think one thing I'd say about the way this market has developed over my time in practice is that the market for expert assistance is increasingly global. You do not just look in your own jurisdiction. Of course, it's helpful if your expert can be down the road or in the same time zone. But I've certainly had the experience of looking around on a global basis for experts and coming up with people, the right people in the wrong time zone and making that work. And I remember a matter in Singapore where we cast far and wide for appropriate IP expertise on a matter and ended up finding some of it in the US and some of it more locally. And that was in the day when people actually flew for hearings rather than appearing online. But of course, even these days, it's even more convenient to look for your experts globally. And I think Indian experts, therefore, are part of that global talent pool. India contains many world-class experts appearing in proceedings not just in India, but globally. And the tribunals value that expertise. I sit myself as an arbitrator, as I mentioned, and I appear as a counsel. And I can tell you that as a tribunal, you value the straight-talking expert help that experts are a well-instructed and well-positioned expert is able to bring to the process. There are many disputes which would be quite impossible without good expert assistance. Of course, valuation in matters. Tribunals who are more or less numerate rely upon experts to assist them with that valuation process. But other types of disputes, I had a long-running matter in relation to what is now termed negotiation damages under English law, used to be called Rotham Park, where a tribunal is asked to come up with a number that would have been reached through a hypothetical negotiation. Now that, of course, requires somebody with an independent and unbiased mind to apply their expertise to the situation in question. And also, of course, competition damages, another increasing area for expert assistance to help tribunals or courts come up with a counterfactual in cartel damages cases. I'm sure we'll get onto the topic of hot tubbing in this debate. I look forward to those contributions. Incredibly valuable, I think, where it works well, but I think it also requires a degree of energy and assistance and lead from the tribunal to do so. And of course, also, I'm sure we'll get onto the topic of virtual hearings and how that has changed the expert's role in the process. So overall, I very much look forward to the panel discussion. Thank you again for the opportunity to introduce the panel, and I look forward to giving some comments later on. For now, I think, Geetu, I'm going to hand over to you to take us forward.
So thank you, Nick, for setting the tone for the panel discussion. Now invite Sumit to kindly open the discussion with other speakers today.
Thank you, Nick, for those opening and very very relevant comments from a perspective of international arbitration. Good afternoon, participants, once again. Good morning to those who are in a different time zone, behind India. And thank you for joining this session with some of the finest experts in the room. I'm privileged to moderate this session, and we have over 200 participants, so really fortunate to be moderating this. As Nick mentioned, there has been a regular practice of engaging experts in arbitration in India and globally. It's at various stages one uses the experts to strengthen the arbitration process, and the experts can be financial, even technical, architects, engineers, or scientists and researchers. Let me start by posing a question to Tom, and then I'll move on to the other participants on what do you believe are the attributes for which an expert is appointed, which can actually define how effective the person is. So over to you, Tom, to bring those attributes which require the effectiveness, which actually displays how effective an expert is.
Thank you, Sumit. Well, I think this is a very interesting question, and it's always one of those quite intense stages at the beginning of an arbitration when you need an expert and start to get to the question of who should your expert be. So I really think it's quite a consequential decision. And so we feel the responsibility as counsel to get it right. And so I wanted to think about, well, how do I approach this as counsel? And you'll also hear in my responses some observations from sitting as arbitrator, and so seeing how experts come across at the end of the day. And it seemed to me there were really 4 different categories of quality that we assess experts on, whether we do so sort of thinking that we're doing it or just at the back of our minds. And so I'm going to quickly run through those. The first is, and this might sound like a cliche, but I really think the first factor we look at is integrity, because an expert who doesn't have integrity is just no use at all to advancing your case. A lack of integrity shows up very quickly at a hearing, and those are the experts that tribunals just don't find useful. And so that's something that we do look out for at the selection stage, because there are opportunities to show your integrity during that selection process. Obviously, we respect somebody who was clear with us about what they thought were the problems in the case, or were clear about how aspects of the evidence might be outside of their expertise. And of course, as an expert, your reputation in the market is incredibly important. So that's the first factor, and I suppose that's a gateway factor. If you don't meet that basic integrity test, then there's no point keeping going. The second factor is obviously expertise. It's in the name of the role, but that's not an easy factor to assess always. Obviously, with a quantum or evaluation expert or an accounting standards expert, that's a very well-defined area of expertise, and it's quite well understood what that expertise means, and it's reasonably straightforward to work out whether somebody has the expertise that they claim to in those areas. But later in the session, we're going to talk about technical and commercial experts. And I think there it can be harder to assess whether somebody really has the right expertise, and that requires some thought. And sometimes we just don't have as much choice as we would like in selecting that other category of expert. The third category is what I might call tribunal-facing qualities. How is this person going to appear in writing? How clear will they be? How rigorous are they in the way that they write? And how well are they going to be able to answer questions from the tribunal and ultimately be cross-examined? And then the fourth category is what I would call teamwork qualities. We're always very aware that when we work with an expert, we're bringing on a team. There's much like at a law firm, it's a partner, there's somebody who is at the head of that team, and they're an incredibly important member of the team. But I have a practice that I would always want what I would think of as the sort of senior associates on the expert side to also be involved in the pitch process. And I'd want to understand who that person is, because I know that's one of the people that we're going to be dealing with a lot, and I'd want my own associates to have interacted with their peers on the expert side. because we know that that's an important part of the process. So I hope that's a useful framework. It is a really important thing to get right, and it's something that certainly keeps me awake at night.
Thanks, Thomas. And absolutely, the first point which you made, integrity, which for me also, for any expertise or in any case is paramount. So with that, let me ask Geetu, who's who works as an expert herself. What do you believe, Geetu, are attributes which make a expert effective in the arbitration? Let me also add one more dimension to the question, if you can add to that, how's this attributes changing over the years? If you can point to both the questions for the audience.
Sure. Thank you, Sumit. And I must say, I think a very testing question for me to start the discussion on. Tom, thanks. And I think you've really sort of simplified my job on this one. Very well said. I completely resonate, large part with Tom, what you mentioned. So on the first part, Sumit, of what you're saying is, what are the key attributes? If I were to go by my personal experience and, the experience of, the fellow experts I've seen over a time span, I would say that taking forward from integrity, which is of course core, independence is crucial, which I think also independence and integrity, I think really go hand in hand. And therefore, if that's there, it brings about the neutrality in the expert. So I would say that the most successful expert or the most impactful expert is somebody who's neutral and, governed by a very fact-based, a very objective approach-based sort of opinion he or she forms, and not necessarily by, one side of the story which has been produced to him or her. I think the second very crucial part, which has always been there, and I think even here to stay, and even as the role of experts evolve, is what is critical is the ability of the expert to understand what is the role that she or he is actually playing in the entire dispute proceedings. There are situations where, because a lot of the experts are subject matter experts, I would say that, I would want to say the liberty of saying that, subject matter experts in a lot of situations have the habit of getting, let's say, overwhelmed, where opinions are being sought. And I think that poses a threat in the sense that, the expert may actually transcend beyond the scope of work. And I think, not really putting back the opinion to what he or she is supposed to deliver. What is the, relevance to context in that dispute, etc. The last part of the question, Sumit, where you said that how these attributes are changing. I think one of the key change that I have personally seen over the years, and I'm sure that, my fellow testifying experts, may also agree with me, is that if I were to see, the selection of experts which used to take place, let's say about 2 decades back or 15 years back, or let's say a decade back, there was a lot of emphasis on not so much of, as one would say, seasoned experts, but on subject matter experts. Technical competence was key. Technical competence still remains key, because I think that's really the foundation of why at the first place, you want an expert there, because you want a very technically sound opinion. But I think over a period of time, what's become very, very crucial, and also, brings out the difference between a seasoned expert and, let's say, a subject matter expert, is where an expert who's able to strike a very fine balance between the technical competence and at the same time carrying a very sharp ability to clearly communicate, clearly well articulate his or her opinion, high quality opinion, both in writing as well as, what they, verbally deliver in a cross examination. So that would be my take, Sumit. Back to you.
Thank you for those comments, Geetu. And let me now, come to Amanda to ask, the question about the evolving role of experts. Amanda, what do you believe is in your experience, how this role has been evolving in case of cross-border disputes? And also, Are you seeing any differences in the trends, in Asia versus some of the other seats of arbitration where you operate, and more specifically, with a context when I say Asia to India? Over to you, Amanda.
Thanks very much, Sumit. I think one of the key things which has perhaps already come out a little bit in this webinar is in terms of integrity and independence. And one way in which I think our appreciation of the role of the expert has evolved is the appreciation that the expert's duty is to assist the tribunal rather than being an advocate for the party. And the very best experts, that comes across, that they're trying to actually assist the tribunal when they're delivering their expert report, and in terms of the way they answer the questions, and not acting as an advocate for the party. And that's why the independence, impartiality and integrity is so important for an expert. As Nick already mentioned, the other way in which it's evolving is the fact that there are a growing number of global specialist expert practices, particularly in the construction and quantum fields. In fact, I struggled to keep up. Thank goodness that Geetu has stayed with PwC, because I've struggled to keep up with how experts have moved around between a number of practices, and there's a number of new expert practices. So really it has become a much bigger sort of field of practice, being an expert itself, compared to what it was like even 15 years ago. And that includes in Asia. I mean, there's increasingly number of experts based in Asia. There's a number of firms set up in Singapore and doing work across Asia and globally. As Nick mentioned, experts based in Asia are appearing in courts in Australia, in the courts in the UK, not just appearing on matters in Asia. So really, Asian experts are being recognised for their expertise, and it is becoming a global practice. I think one of the things that I'm noticed both as arbitrator and counsel is that in very large matters with sophisticated counsel involving Asian parties, you see parties instructing experts on both technical quantum issues. What's interesting is that for the sort of medium-sized disputes, you sometimes, with Asian respondents, you sometimes see that the claimant has instructed an expert and the respondent doesn't instruct an expert in response. And I think this is perhaps because they're represented by less sophisticated counsel. I've seen this in some Indian matters. I've seen it in matters involving parties from other Asian jurisdictions as well. And I think it then becomes very hard for that respondent to actually challenge the expert evidence when they haven't instructed their own expert. And really they're missing a trick there. Usually there is a basis for trying to reduce the quantum, even if you know you're going to lose at the end. There's often a basis for trying to challenge the quantum. And I think, especially when you sit as arbitrator, it's sometimes a little bit frustrating where you think, I'm not so sure about this, but there's no one actually challenging that evidence. And I think that's something which it'll be interesting to see how that develops in that sort of medium-sized disputes. Obviously, in large disputes, Asian parties are using experts just the same as everyone else is in the world, but in those sort of more medium disputes, perhaps still not so much familiarity with the value of expert evidence.
Could I add something to that? Because I think that's a really important point. I also look at it from a slightly different angle, which is, although we're kind of focusing on the experts and how the qualities of an expert, there's also the question of the instructions they're given and the role that the experts are given by the lawyers when they're framing a case. And if we go back to the age-old questions about efficiency and the conduct of arbitrations, I think something that can happen is that, through no fault of the experts, they get asked to develop a case which, as it turns out, doesn't really make much difference to the findings that are eventually going to be made, because it's based on, for example, sets of instructions that make the opinion so narrow that you don't get into that set of instructions, then the opinion's not so relevant. But it's important because, as Amanda says, if one side, for example, starts developing expert evidence, you have to be very brave to not bring in your own expert to respond to it and make sure that you are taking that expert on their own terms, even if in reality there's so many sort of assumptions, for example, built into what the expert's saying, that there will be other ways of eventually attacking it. So if we go back to that kind of question of efficiency, I think there's a real responsibility on lawyers to use experts well.
Absolutely, bang on, Thomas. And I think you said it right, that while expertise, experience, everything is important, but also the right instructions. I think just to probably wrap this part of the discussions over, the increased complexity, the cross-border transactions, and now virtual environment are making the role of expert also relevant and in some cases complex. I think these changing trends would necessarily help in making dispute resolution process effective, efficient, and in some cases cost effective too. While I'm moving to another theme, I also invite participants to please post any questions, comments which you may have. We definitely would like to keep some time towards the end of the discussion for addressing your questions, comments. Let me now shift the gears a little bit and move on to Aditya to ask about, what do you think are your key determinants or advice from a perspective of technical quantum experts in large disputes where which requires far more sharper focus. How can technical and quantum experts be more collaborative? So where you have multiple experts coming together, how do they work together? Aditya, over to you.
Thanks, Sumit. So look, I think Amanda and Thomas have already spoken about the onus on the experts and counsel, right, in terms of providing the right instructions. But I do think that there is this inherent tension, the pressure that experts feel to sometimes go out on a limb to please the client that has engaged them. And there is therefore a risk of coming across as a hired gun. And so my view is that a lot of the onus also falls on the arbitrators. And there are procedural mechanisms available to them, right, to the tribunal to ensure that expert testimony at the end of the day is more productive and cooperative. And there are sort of three things at least that come to mind, largely driven by the tribunal, which can happen at the initial stage of the arbitration, at the sort of midpoint or before the hearing, and after the hearing. The first, of course, is what is called the Sachs protocol, which was proposed in a paper by Dr. Klaus Sachs at the 2010 ICA Congress that happened in Rio. And the idea here is that each party essentially proposes a list of potential experts, and the tribunal chooses one person from each party's list. And what ends up becoming is an expert team, which is answerable to the tribunal, right? And so that's something that can happen at the start of the arbitration. And it also sort of takes away the hired gun concern that people have with expert while ensuring that parties have some control on the identity of the expert. The second way of perhaps doing this is through a mid-arbitration procedural hearing, right? Where once the first round of submissions is complete, instructions can be given to experts to narrow the disputed issues, and specific questions can be asked by the tribunal that they want addressed in the next round. And this sort of reminds me a little bit of Lucy Reed's idea of a Reed retreat, which she identifies as a gathering of tribunal members before the start of the hearing to discuss the impending hearing and to consolidate the issues. So if there was to be a Reed retreat of some sort, then the experts could be given more targeted questions. And the final thing that can happen after the hearing, and indeed I do believe anecdotally that it's done by some tribunals and in some cases, is this technique of targeted homework, where once the hearing is over and the tribunal has appreciated the issues in dispute and what are the sort of, the separating points between the experts, the tribunal can then ask the experts to submit an additional short targeted opinion on the specific questions along with the post-hearing brief, and even have a short additional hearing at which the experts are cross-examined again on their new submission. So these are just some of the ways in which I think, the tribunal and the arbitrators can ensure that experts are working in a more cooperative fashion and are being more effective.
Thanks, Aditya. So let me also pose a follow-up question to that to Amanda, that in case of large and complex disputes, particularly in the infrastructure and construction or real estate type of a sector, is there a different approach which you as a counsel would be adopting to select and brief technical or quantum experts? Amanda, to you.
Well, I think it's much easier to select some experts than others. Nick already mentioned this in his opening remarks, is sometimes you need expertise in a very technical and niche area, and that becomes much more difficult. Whereas for a lot of construction disputes, as I've already mentioned, there's some global firms that have expertise on the quantum side, the delay side, the programming side. And so you have a wider range of experts to choose from who have testifying experience and are more seasoned. And so it's a little bit easier to select them. And then some of the considerations you might want to think about whether or not there's going to be any conflicts of interest. And there's been a couple of trip-ups in that case in the last few years. And whether or not the experts, you then go to the sort of next level. Okay, they've got the expertise, so the quantum expertise. Do they have expertise as well in the particular sector you're looking at? Like, for instance, if it's to do with a particular type of civil infrastructure, has that person been involved in that particular area before? And you can really drill down to find someone who's ideal, both in terms of the expertise, the sector, the jurisdiction, etc. With technical experts, it can be really hard. As Nick said, they're difficult to find. One of the questions actually that one of the attendees has asked is whether or not there's a readily available database from where experts can be selected and approached. For some areas, but not all others. There are a couple of firms that have now set up. I know there's an organisation in the UK that can help with finding experts. I know there's an organisation in Australia that's also got an office in Singapore that can help with finding experts. There are actually people setting themselves up to do exactly this job. Because in really niche areas, it can be extremely difficult to find. You need to throw the net often wide, look in multiple jurisdictions, because you need someone, and because often you're not going to find someone with testifying experience. So therefore, you need someone who's really got that expertise that you need, who's got the sort of deep experience in the area. And you know that you're going to have to spend a lot of time assisting them in terms of briefing them, assisting them with how the report is presented and how technical issues are explained to the tribunal, which I think is something we're going to talk about a little bit more later on in this webinar, and then how they go about testifying. I mean, I've had the experience in one proceeding where we needed expertise in fire safety, and this was quite a niche area. There weren't that many experts available, and we realised partway through the proceeding, I hadn't been involved in selecting the original expert, had come on board, as sort of a bit of a change internally, and realised partway through that our expert was the wrong person. They didn't have the right expertise. They weren't as knowledgeable as the expert that had been brought on by the other side. And we were able to, fortunately, by means of a reply report, get in another fire safety expert who had been identified. But it's quite, I think, as has already been mentioned, the importance of getting the right expert at the beginning, because changing expert mid-course is quite difficult, involves kind of procedurally working it out, but sometimes happens in these niche areas because there aren't people with testifying experience. There aren't very many people to talk about who've seen them before. And so you really need to very thoroughly examine the person at the beginning to make sure that they're going to be able to do the job when it comes to the actual hearing.
Thanks, Amanda. That's really helpful remarks there. Tom, let me come to you with a kind of a related topic about use of professional versus or seasoned experts versus occasional experts who have deeper knowledge of the subject. So there's always a debate or question in the mind of the councils or the companies who are appointing, that whether to use an expert who's familiar with the process versus an expert who has a deeper knowledge but may not be very familiar with the arbitration process, who is called an occasional expert.
Yeah.
What is your experience? Where to go, and what is the best way to approach this dilemma?
Well, I think it can be really difficult, right, as Amanda was saying, and Nick has said, when you're looking for quite a specialist area, finding people who even have that particular experience and are not kind of involved or related with the parties can already be quite hard. And so finding someone who not only has that, but is a very accomplished testifier is particularly hard. So the starting point is we can't really design a perfect world often when it comes to this category of experts. My personal practice is to place quite a lot of weight on whether somebody has testified at least once before, because I do think there's something really different about being cross-examined compared to dealing with other robust environments. And I have had commercial and technical experts who have had quite senior positions, so they presented in robust environments to boards and other venues, but ultimately when it came to being cross-examined by a skilled cross-examiner, weren't able to hold their own. And in a way, I think it was quite disappointing, because I feel like they really did know what they were talking about and believe what they were talking about, but they couldn't find a way of communicating that in the context of a cross-examination, partly because they allowed one example I'm thinking of, they allowed the cross-examiner to kind of wind them up. And so the sort of expert became sort of quite unlikable, which was not his personality at all. And I've seen other sort of variations of that, because ultimately you do have this challenge of not only communicating the information, but doing it in a way that the tribunal finds believable and compelling. So I do place quite a lot of weight on having testified at least once before, but ultimately you have to sort of take what's available.
No, I think very relevant. I guess many times it's a challenging thing to choose an expert, but I think those are helpful remarks that to take a approach where a person has a far more experience of dealing with the process can help. Thanks.
Sorry. Could I add half an extra point? I think this is also very related though to this question. Amanda was talking about the example of when she had an expert who then, when it came to it, wasn't the right expert. And I think that can happen in sort of two reasons. One is sometimes we make a mistake when we appoint the expert. That's kind of on the lawyers. But what I've seen, and this kind of pairs up to whether someone's going to be able to withstand cross-examination, is sort of a creep in what's required of the expert over the course of the arbitration. So what they end up testifying on is not really what they were holding themselves out as being an expert on in the first place. And that's a really dangerous combination, because, and often this is the expert trying to be helpful in kind of not giving you the view they want, but sort of doing their best to answer the revised question or issue that they're now dealing with. And it's one of these sort of boiling the frog situations where the changes perhaps have been quite incremental over time, that you can wake up before the hearing and realize this expert is now not really an expert in their area, or certainly not an expert in the sense of being able to talk about it in a compelling way, even if on a piece of paper, they still know about this kind of industry or piece of machinery.
Yeah, thanks for that, Thomas. Really helpful. Aditya, I want to quickly, provide any additional comments, or one of the topics I had in my mind was productive use of experts in case of investments treaty arbitration, and how's the maturity level of some of the states in these matters. so that we can, close this one and then move to the next.
Yeah, no, Sumit, I'll address that very quickly. I'm conscious we're running out of time. There are some studies, no hard data, to suggest that the use of experts is even greater in investment arbitration as compared to commercial arbitration. And on your second question about maturity, right? In terms of how states use experts, the reality is that oftentimes it has much to do with the counsel that are involved. So if a state has sophisticated international arbitration counsel involved, then one would hope that the right kind of expert would also get selected. But when we're talking about treaty arbitration, one has to be conscious that, in developing states, right, when they're involved, there are serious access to justice issues, and a number of states have frequently struggled to fund their legal defense. And that often means that they don't have the resources to engage the best experts like you because you're more expensive.
Yeah, helpful. Thank you. We are not that expensive, by the way. but once again, thank you, participants, for posing the questions. A few of them we'll try and cover in the topics as we move along, and the balance we'll try and address within this forum, if not later through an emailer. So moving to a little bit different topic. Geetu, let me come to you and ask that many a times that expert reports are actually based on available evidence, or what we call as a limitation. So do you think that such reliance on limited information may pose a risk for the opinion or the report to be more theoretical in nature than actually aligned to what the real requirements of the arbitration are? Yeah. So Geetu, over to you.
Sure. Thanks, Sumit. So, Sumit, this I've seen this has always been a very controversial area of discussions, and I think the very straight answer to this, and I would just kind of keep it short in interest of time, is that there is no shying away from the available evidence, and I think one has to, as an expert, rely on it. But what is crucial here is that it is not just the evidence, which has to be seen in isolation. There's also the approach methodology, and experts are always encouraged to apply proven approach methodologies, because a combination of the available evidence, the way you examine the evidence, how relevant it is to the matter of case in hand, and how what kind of robust and proven approach methodologies is what you apply will actually determine how good is the quality of the evidence that is produced. So I think, having said that, I would say that not to look at the available evidence in isolation. Of course, it's the key, and there's no shying away from it. There are different ways that an expert can actually put a stress test on their opinion, which they derive in their work product, based on the evidence they've relied upon. One has to sort of pick cues from the practical business world and, apply it back in, let's say, the baseline assumptions that you take, in the procedures, we sort of adopt. One can build so many sensitivities and scenarios. So there are several options. So I would say that, experts are always encouraged, to take it as a bundle of wisdom and, application of these multiple things, so that the ultimate work product is something that serves the purpose of why, the tribunal at the first place, would have seen the relevance of an expert, and, not delivering an expert report or a work product, which is just merely theoretical in nature. So that's my take. So back to you.
Thanks, Geeta and Geetu. And now to a topic which has also been asked as a question by Mr. Prasanna. So Aditya, let me ask you this one, and then I'll come to Amanda for her comments. Hot tubbing, this is a procedure which has long been debated as to whether it's effective or not in the tribunals to assess between differing experts and complex matters where there are differing opinions. How do you see this as evolving, and is it really effective?
Right. So Sumit, for the uninitiated, and to clear any doubt, the hot tubbing we are talking about is a technique where witnesses are questioned together by the tribunal and possibly by counsel, as opposed to being cross-examined, right? And in terms of trends and how it's developed, the headline for me, Sumit, is that the use of the hot tub is not as prevalent as one might imagine, right? It's been now, over 20 years since Wolfgang Peter wrote his famous piece in Arbitration International, which was called Witness Conferencing, which in some sense really brought the idea home to international arbitration practitioners, even though hot tubbing has been used from the mid-1980s in Australia, where I believe it was first started. But despite of some of its advantages, the reality is that the technique has not taken off in a big way because of some of the fundamental weaknesses. The first one being that unprepared experts, right, can get off the hook in a hot tubbing situation sometimes because they are not subjected to a searching cross-examination. Second, for the process to work, right, it can really only work if the tribunal and the president are very well prepared in advance of the hearing, have understood the key issues, and are ready to ask targeted questions. And as we all know, unfortunately, that is often not the case, right? And even if they are prepared, sometimes arbitrators only realize what issues most trouble them once they've seen the two experts being cross-examined. And finally, the other problem is that witness conferencing tends to favor, right, the expert who has a stronger personality or has better oral presentation skills. And that is often, that's not the determining factor. And that is another problem. So I don't think it's taken off in the big way. It's not been adopted as much as it should have. And perhaps these are some of the reasons.
Yeah, no, thanks, Aditya. I think the way I look at it, and I'll let Amanda add that various jurisdictions are also looking at it differently. In some, it is a little bit more accepted, like Australia versus some of the others. Amanda, over to you to add to the concept of hot tubbing and how you see it evolving and helping. Yeah.
Well, I suppose I have a bit of a different view to Aditya, perhaps because I am Australian. No, we actually see it being adopted in international arbitration. It's been adopted in a number of arbitrations in which I've appeared as counsel. I've also used it myself as arbitrator. I do think it's not always adopted, but I do think it can be extremely useful. There are different ways of going about it, which address some of the issues that Aditya posed. So, for instance, the Singapore branch of the Chartered Institute of Arbitrators actually came up with quite nice little guidelines and draft procedure orders in relation to concurrent witness evidence, which go through some of the different ways you can do it. So it's not always necessary for the tribunal to take the lead. Often, actually, it's counsel that take the lead in the questioning, and this way you can actually get those sort of deep and searching questions that Aditya was suggesting. And I find the reason I think it's helpful, and I found it helpful as arbitrator, is because you have both experts there at the same time. So not only do you get the response from one expert to the question, you can then have the opposing expert respond to that. And sometimes you even can have the experts, ask each other questions as well as part of that. But it means you get an immediate response. And so it means that you don't have that issue where you have an issue that's only been addressed by one expert and not addressed by the other. And immediately as tribunal, you can see the position that both parties are putting. So personally, I find it very helpful. I do think that it does require people to have experience. It requires counsel to have had experience to get the most value out of it. It requires the experts to have had experience of it, and it requires the tribunal to have an experience of it. And if they do have experience of it, I do think it's a valuable tool that can be used in order to one, bring the parties' experts perhaps a little bit closer together, but also get a real exposure of where the differences are and what the different views are.
No, thanks for that. Amanda, the situation where I was put in a hot tub, I was very, very nervous because you're not prepared to be in that situation, but no, very helpful remarks. So with that, let me get to the last topic, and very quickly, I'll probably ask each of the experts to take a minute to talk about where do you see the future of arbitration. And Tom, I'll start with you. And I also want you to cover, the subject which Nick mentioned and which I thought I'll also cover, the virtual courts. How do you see that evolving in the near future? Do you think virtual courts are going to be the way? And also, you think in the new, evolving economic and geopolitical situation, how it'll have the impact on the experts? So 2 parts. One, how virtual courts will, evolve over the years. How do you see them evolving? And second, in the new environment, the role of experts. With you, Tom, and if I can request for each of the panelists to take a minute to summarize their thoughts on this.
Well, then on virtual hearings, I think we would probably all agree that they are here to stay. They're not usually my preferred way of having a more substantive hearing, where I would want to at least be with my own team all in one place. And I quite like to also be able to look the tribunal in the eye and sense their body language. But we can certainly accommodate the virtual hearings, and they'll often be required, at least for short hearings. And I think that compromise is fine by me. In terms of the future of expertise, I think something we haven't really touched on is the kind of new areas of expertise that will be required in the future, which I'm now starting to see more and more. This particularly comes out of my tech practice. Having people who can speak fluently about the types of issues that arise in tech-related disputes, which often involves understanding the underlying technology or code or commercial logic of a product, can require quite specialist expertise. And there isn't a lot of infrastructure set up around helping us find those types of experts. So we can contrast that, for example, with the oil and gas industry. There's a big sub-industry of kind of retired people who used to work at Shell or BP and are now consultants and are quite keen to be experts, but try and find somebody who can really explain to you how this piece of Google ad technology works, or what the trading patterns of cryptocurrency are and how you should look at that in terms of valuation of an asset or any of these other areas. It's really quite hard to find people who have the expertise and are good at testifying. And I think that's going to become an increasingly big occupation for us.
Thanks, Tom. Amanda, let me ask you the same questions and your comments and remarks on that.
No, I agree with Tom. I think that the area of technology disputes is only going to get bigger, but in terms of arbitration. And one of the challenges there, and I mean, I was fortunate enough to work on the Apple and Samsung proceedings many years ago, and one of the challenges there was finding someone who was acceptable to the parties, given the confidentiality of things like the code that needs to be examined. And also making sure that they're actually able to work in the industry after the matter is finished, given that they'd seen the code. So there's all these sorts of considerations to do with the extreme confidentiality, especially where they're new products and new code involved in terms of allowing people actually access to the technical nature of the technology and the products themselves, which makes it a real challenge. One of the things we haven't talked about is the use of tribunal-appointed experts. That's something where I do agree with Aditya, not something that we actually do see. And I suspect that will continue in the future. I think we still will see parties using party-appointed experts into the future. I think expert evidence is here to stay. What I do think is that we all get better at how we use expert evidence and explore new possible ways of ensuring that we get the best bang for the experts in terms of both as tribunal, as counsel, and as parties.
Thank you, Amanda. Aditya, any further additions to this?
Well, I agree with Amanda and Thomas that technology disputes certainly will require more expert involvement. But Sumit, now I've been in Asia for around 5 years, having previously practiced in the US and Europe. And 10, 12 years ago, Europe saw a big boom of gas price review arbitrations in the LNG markets. And if I could identify one trend that I have noticed in Asia in the last 5 years is this tremendous growth of LNG price review arbitrations, right? And because price review arbitrations, more than I think any other types of disputes I've done, rely so heavily on expert evidence, right? You need solid, experts from the industry, you need gas economists. I think that is definitely an area where we'll see an evolving and an increasingly important role of the Asian expert, or an expert who sort of specializes in this area in the region going forward.
Yeah, thanks for that, Aditya. Geetu, coming last to you for, where do you see future of arbitration as an expert here? Geetu, you're on mute, I guess you need to repeat.
Oh, I'm so sorry. Apologies for that. So thank you so much, Sumit. And I'm extremely, delighted, and I have to say that thankful to all my co-panelists for bringing out such a tremendous, bright future for, the increase in the use of experts in future. I completely resonate. I think the broad spectrum of the kind of expertise one requires. Yeah, I think the use of domain experts will definitely increase. Technology, IP, etc. I think is one big area. I do see a lot of, the whole area of construction infrastructure anyways has gained a lot of sophistication around the use of experts, and even fields like pharma, where core specialists, sort of maybe could be brought forward, etc. So I think the list is long, and therefore I think a big shout out that, any subject matter expert looking to pursue something like this is a career very safe bet. The second, your question was on the virtual courts, Sumit, and I would say that in the event that, the virtual court scenario is here to stay, I think experts have recognized that, that is that's a way they will have to sort of adopt towards. The duty of care of the expert practically remains the same. So virtual court or not, the work product anyways that goes in writing, what we call as the expert evidence, is that format remains the same. And even the onus on the experts to deliver very, very clear opinions in cross examinations, whether it's a virtual court or in person, remains the same. I think experts will have to gain their comfort in this new format, and that's where it is. And the third, I do recall that you brought about that in this entire evolving economic and the geopolitical situation that's really sort of prevailing across the globe. Yes, I think it puts a huge onus on the experts. Experts will have to factor in all the uncertainties which are developing, and they'll have to amply and appropriately demonstrate how the impact of the same has been factored in, any sort of quantification damages, or even in the technical advice, that's given henceforth. So that's my take, Sumit, and back to you.
No, thank you so much. And thanks to all the panelists for an engaging discussion. And I see many attendees, or most of them, still there with us. So thank you for all the attendees to be attentive as well as participating in this discussion. With that, let me hand over back to you, Darshan, for concluding this discussion.
Sure. Thanks to all the participants. Thanks to all the speakers, and a great thanks to MCIA for organizing this session. Just one word of advice, as I hear from all the councils here, is as an expert, independence, integrity is a given. The topic is technical, the topic is complex, but that's why you've been appointed as an expert. Make your reports, make your opinions easy for the tribunal to understand. Any last points, Nick, from you?
Thank you, Darshan. Look, that's been a very interesting discussion. Thank you, everyone. Thanks, Sumit, for chairing so adeptly, and thank you for all those very interesting and insightful thoughts. Yeah, I think I'd echo the themes that have come out, really. I think one early comment that struck me is that experts must be communicators. You must be able to get the ideas across to the tribunal. I think that therefore helps if you're a professional expert, if you've got that practice. But of course, good communicators can come from anywhere. It's important you will be given space by tribunals to explain, because as I mentioned, tribunals are hungry for your expertise. They want the help. They want the expert help. So you must use that space and then educate the tribunal. You must communicate and also educate, and especially in areas, as has been mentioned, of highly technical subject matters. I mean, frankly, valuation is a highly technical subject matter, but we'll be dealing with, some interesting disputes in the years ahead in the realms of tech, in particular in the realms of the cyberverse, where those of us who are a little bit older might struggle to get our heads sometimes around some of the aspects, and we might even think the tribunals could struggle to get their heads around them. So it's important that experts really assist that. And when you're working with experts, just bring them on early. Have early conversations with your expert, make them part of a team, as has been said. Experts can help you look in the right places. Nobody can help you create facts, but they can help you to find the right facts. And then to have a candid conversation about the strength of your case. I think has been mentioned by Aditya. No one is helped by an expert who is asked to overextend on an opinion and who accepts that invitation and puts themselves at risk of having their credibility damaged and are actually harming their party's case at a final hearing. So it's important to have honest and candid conversations as well. But a great learning experience today. Thank you very much to PwC and to MCIA for putting this on.